uh, YouTube channel, Michael Imhotep, and right here on 910 AM, the Superstation, WFDF here in Detroit. It is Thursday, November 4th, 2021, and we are live. Welcome to the African History Network show. So on today's show, we're going to give an update in the trial of the three white men accused of killing Ahmaud Arbery. Now, we know at the end of yesterday's show, we did an update on the election results. We talked about the Virginia governor's race. We talked about the New Jersey governor's race. We talked about election results here in Detroit as well. And at the end of yesterday's show, we dealt with at the end of yesterday's show, we talked about 65 potential jurors. Okay, 65 potential jurors had been selected. Okay, and then we found out that they actually selected the 65 potential jurors. Then we found out they actually selected the 16 jurors, 12 jurors plus one alternate, 12 jurors plus one alternate. Now, what is causing a lot of people to be concerned is that you only have one African-American juror on the jury. Out of 16 potential jurors, only one African-American juror. CNN has an article about this, New York Times. I've been watching a lot of news coverage on this today. And last night on Yodit Tawalt's show on the Black News Channel, making the case, she had a really, really good legal analysis of all of this. And she posted about it on her Instagram page today. I talked to her for a quick minute through Instagram. I'm going to share that with you. She's an attorney. I made contact with her some years ago. I actually talked to her back in, I think, about 2016 when I used to guest host Roland Martin's nationally syndicated radio show. And she made a really, really good legal analysis and a breakdown of what's taking place and the reverse Batson challenge, So Judge says, we look at this piece here from CNN, from CNN.com. Judge says there appears to be intentional discrimination in Arbery jury selection, but allows trial to move forward with one black juror. And a lot of this has to do with Georgia law when it comes to striking jurors. So we're going to discuss this. And then also they talked about on Roland Martin Unfiltered today as well. So we'll share a segment from Roland Martin Unfiltered. I'll be back on Roland Martin Unfiltered on Friday. You know, I'm a panelist usually each Friday on Roland Martin Unfiltered, so I'll be back on Friday. Now, on yesterday's show, we talked about the Danville, Virginia race riot of 1883. The Danville, Virginia race riot of 1883. And it surrounded a political election. Okay, Danville, Virginia. We know you had the Virginia's governor's race that just took place. Republican Glenn Youngkin beat former Virginia Governor Terry McAuliffe, who's a Democrat. And, you know, I on yesterday's show, I shared the excerpt of Roland Martin Unfiltered when I was on from Friday, October 15th. I said what Terry McAuliffe needs to do to win. He didn't do that. One of the things he should have done is ran on the $1.9 trillion American Rescue Plan that Democrats passed back in March of 2021. And they wrote the bill, and it was only Democrats that voted for the bill in both the House and the Senate. So November 3rd, 1883 was the Danville race riot in Virginia. Also on November 3rd, in 1874, you have the Eufaula, Alabama race riots surrounding a political election as well. These were the election riots. 3rd, 1874 in Eufaula, Alabama. So November 3rd was the anniversary of a number of different things taking place. And that's usually right around a political election. You had a race riot in Virginia in 1883 on November 3rd. And then you had a race riot in Alabama on November 3rd, also in 1874. Okay, so we're going to talk about the November 3rd, 1874, Eufaula, Alabama election riots when the White League attacked African American voters. When the White League attacked African American voters. Now, the White League was another domestic terrorist organization of white supremacists. It wasn't just the Ku Klux Klan. There were a number of them. The White League, the Knights of the White Camellia, the Ku Klux Klan. There was a number of them. You can throw the White Citizens Council into there as well. Okay. All right. So we'll talk about that today on the African History Network show. Then we'll also give you information about the 10-week online course that I teach on the weekends, from the Civil War to the Civil Rights Movement and Black Power, 1865 to 1968. From the Civil War to the Civil Rights Movement and Black Power, 1865 to 1968. And then also understand the transatlantic slave trade, what it didn't teach you in school. Now, on the African History Network show, we focus on educating, empowering, and inspiring people of African descent throughout the diaspora and around the world, because right now it's correct wrong behavior. What you do for yourself, what you do to yourself, and what you allow other people to do to you and get away with is based upon what you think about yourself. What you think about yourself is based upon what you have been taught about yourself. What you've been taught about yourself is based upon everything you've read, heard, and seen about yourself. So when you control the radius of a man or woman's thoughts, you can control the circumference of his or her actions, because the mind can't do or teach what it doesn't know. Now, we deal with a number of different topics here on the African History Network show. We deal with current events and history and politics, education, economic empowerment, entrepreneurship, relationships, love, sex, health issues, and much, much more. Sign up for our email newsletter. Text the word Kemet, Kemet, to 22828 to sign up for our email newsletter. Text the word Kemet, Kemet, to 22828 to sign up for our email newsletter. Also visit our website, AfricanHistoryNetwork.com, AfricanHistoryNetwork.com. All right, we're coming up here on the break in just a minute here. Call-in numbers 313-778-7600, 313-778-7600 is the call-in number if you have a question or comment. I want to look at the article quickly here from CNN. Okay, CNN had a good article here dealing with the trial of in the killing of Ahmaud Arbery. Judge says there appears to be intentional discrimination in Arbery jury selection, but allows trial to move forward with one black juror. Okay, now after a long and contentious jury selection, process in a coastal Georgia county, in preparation for the trial for Ahmaud Arbery's killing, a panel of 12 people was chosen on Wednesday, November 3rd, consisting of one African-American member and 11 white members. Now, even though we clearly see that the defense was trying to strike African-American members, and they complained about the lack of white males over 40 years old without a college education. They called them Bubba's or Joe Six-Pack. At the very same time, about half of the 1,000 people who were sent jury duty notifications did not show up. About 50% of the people who received jury duty notifications did not show up. 1,000 went out. We'll deal with this on the other side of the break. Listen to the African History Network show right here on 910 a.m. the Superstation. I'm Michael Imhotep. We'll be back in a few minutes. Stand by. Stand by, everybody. Stand by. How's everybody doing? Share this broadcasting on social media platforms. Invite your friends to tune in. Stand by. Back from break in 3 minutes. Okay, back from break in 3 minutes. Who still needs to register for the class I teach on the weekends, from the Civil War to the Civil Rights Movement of Black Power, 1865 to 1968. Stand by. Back from break in 2 minutes. Stand by, everybody. Calling numbers 313-778-7600. Stand by. So visit our website, AfricanHistoryNetwork.com. We have the information here. You can register for my online courses. We also have the Kwanzaa shop here as well. Get your Kwanzaa sets, kanaras, candle holders, mats, flags, and more. Add the early bird discount code for $10 off before November 2018. Click right here for the KwanzaaShop.com. Stand by. Back from break in 1 minute. Stand by. Welcome back to the African History Network show right here on 910 AM, the Superstation, the Future Radio. I'm your host, Brother Michael Imhotep. It is Thursday, November 4th, 2021, and we are live. Calling numbers 313-778-7600. 313-778-7600 is the call-in number if you have a question or comment. All right. I want to go back to this article. We're going to look at the one here from New York Times, because the one from CNN keeps showing this very annoying big banner ad for Judge Judy, and since she ain't pay me any money, I'm not going to promote her show. Nearly all white jury in Ahmaud Arbery killing draws scrutiny. Big article from the New York Times. The guidelines that allow the judge to seat a panel with one black juror were meant to remove bias from the process, but have come to be considered a failure by many legal scholars. The guidelines that allowed the judge to seat a panel with one black juror were meant to remove bias from the process, but have come to be considered a failure by legal scholars. Okay, so if we look at this here, we've been following this pretty much every day. Okay, the jury selection, it took a little more than 3 weeks. Took 1 week longer than was originally anticipated. The jury selection went slower. The process went slower than anticipated. There were many objections from the defense as well. Now, even as he approved the selection of a nearly all-white jury this week to hear the murder case against 3 white men accused of killing Ahmaud Arbery, a Georgia judge declared that there was an appearance of intentional discrimination. Okay, Judge Walmsley declared that there was an appearance of intentional discrimination at play. But Judge Timothy Walmsley of Glenn County Superior Court also said that defense lawyers had presented legitimate reasons unrelated to race to justify unseating 8 African-American potential jurors, to justify unseating 8 African-American potential jurors. Now, the defense had 24 strikes, 8 strikes per defendant, 3 defendants, 8 strikes per defendant, 24. The prosecution had 12 strikes to strike potential jurors. And what they did was, for each juror that they striked, each African American juror they strike, they gave reasons they were objecting to that juror other than race. All right, now, and that, Judge Walmsley said, was enough for him to reject the prosecution's effort to reseat African American jurors. Now, it's also important for us to understand, as we said right before the break, 1,000 jury duty notification notices went out. Only 500 people showed up. Okay, so you can't sit on the jury if you don't respond and show up when you get that jury duty notice. What may have seemed like convoluted logic to non-lawyers was actually the judge's scrupulous adherence to a 35-year-old Supreme Court decision. A 35-year-old Supreme Court decision that was meant to remove racial bias from the jury selection process, but has come to be considered a failure by many legal scholars. Now, the guidelines established by that ruling were central to the intense legal fight that erupted last Wednesday over racial composition of the jury in the trial of the 3 defendants, which is set to begin on Friday, November 5th. Trial is set to begin on Friday, November 5th. Now, from many attorneys I'm hearing from, the evidence is overwhelming against the defendants. And the New York Times some months ago had a sequence of video from surveillance cameras in the area, and they showed how long these 3 defendants were chasing Ahmaud Arbery. And there's timestamps on the different videos. So this gives that one. If you go to NewYorkTimes.com and search for Ahmaud Arbery video, you can probably see it. This gives an extended view of the altercation as opposed to just what William Roddy Bryan recorded. The argument raised fundamental questions about what it means to be a fair and impartial juror, particularly in a high-profile trial unfolding in a small, interconnected community where nearly everyone has opinions about the case. So this is something that we've been talking about here pretty much every night. So Glenn County is it's about 86. The population of Glenn County is 85,000, and 26% of the population of the 85,000 residents are African Americans. 26% of African Americans, 69% of the population is white. Okay, according to the 2019 data from the U.S. Census Bureau. All right, now I want to go to this clip here. I want to go to clip number 1. This is from Roland Martin Unfiltered. This is from today, November 4th, and they're talking about the jury selection in this trial. Let's go to clip number 1, Shakita.
Intentional discrimination. That is exactly what a white judge in Georgia is saying took place in the picking of jurors in the Ahmaud in the trial of 3 white men accused of killing Ahmaud Arbery. Let me walk through the makeup, folks, of this jury. Of the selected pool of 65 potential jurors, 48 were qualified. There were 23 white females, 13 white males, 6 black males, and 6 black females. The 12 selected included 11 white people and just 1 black man. The prosecution requested a reverse Batson challenge, which is an objection to the validity of a peremptory challenge on grounds that the other party used it to exclude a potential juror based on race, ethnicity, or sex. Now, although Judge Timothy Walmsley acknowledged, quote, there appeared to be intentional discrimination in selecting the jurors, he rejected the prosecution's motion.
In this particular case, Batson's limitations, I think, are clearly out there. In this particular case, there are these significant overtones of race to begin with. And then we have numerous additional preemptory strikes. We're not just limited to the ones that statutorily set out there. And then we have extensive questioning of each of the panelists, which start differentiating everybody for different reasons based on answers that are given. Because of that, it becomes very difficult for the court to start working through this problem of, are these really genuine reasons that are out there? And it gets to the point that I think was raised actually in the Batson decision. I wrote it down. Justice Marshall in his concurrence was talking about Batson. And he said specifically, the decision today will not end the racial discrimination that preemptories inject into the jury selection process. And the reason he said that was because his view of it was that preemptories just give the parties the opportunity to place the court and the system into this balancing of race versus legitimate purpose. And again, this case makes it difficult because race has been injected into this process, and we have a significant number of preemptories. All that's to say, I've worked through each one of these. I've listened to the defense. Again, in the state of Georgia, all the defense needs to do is provide that legitimate, non-discriminatory, clear, reasonably specific, and related reason. A very adept counsel here, and they've been able to explain to the court why, separate from race, those individuals were in fact struck from the panel. Does not change the fact that that initial finding is out there. Doesn't feel like that is how it worked, but it's been explained to the court under the terms of Batson why those particular strikes were made. And the court is not going to place upon the defendants a finding that they are being disingenuous to the court or otherwise are not being truthful with the court when it comes to their reasons for striking these jurors. So because of that, and because of, again, the limitations I think Batson places upon this court's analysis,
Folks, this, of course, is raising all sorts of questions.
All right, pause right there,
the
Shakita.
trial already began. Today was a hearing.
Pause right there. Okay. We're going to go to clip 2 here in just a second. All right. So you have, if we go back to the article from CNN, name of this article once again from CNN is Judge says there appears to be intentional discrimination in Arbery jury selection, but allows trial to move forward with 1 black juror. Okay, so Judge Walmsley, so the court heard arguments for more than 2 hours today. The court heard arguments for more than 2 hours about why defense struck the potential jurors before Judge Walmsley ultimately denied the state's motion and ruled there were valid reasons beyond race, why the jurors were dismissed. Judge Walmsley said one of the challenges that I think counsel recognized in this case is the racial overtones in the case. We'll continue this on the other side of the break. Listen to the African History Network show right here on 910 AM Superstation. I'm Michael Imhotep. When we come back, we'll go to the phone lines also. We'll be back in a few minutes. All right, stand by, everybody. Stand by. How's everybody doing? Share this broadcast on social media platforms. Invite your friends to tune in as well. If you like this type of information, you support the African History Network. $ the AHN Show through Cash App. $ the AHN Show through Cash App. Also through PayPal, paypal.me/the AHN Show. PayPal.me/the AHN Show. Stand by. We'll post a link so you can register for my online course that I teach on Saturdays also. Saturdays and Sunday. Understand the transatlantic slave trade, what they didn't teach you in school, ancient Kemet, the Moors, and the Maafa. Understanding the transatlantic slave trade, what they didn't teach you in school. Stand by, back from break in 2 minutes. Stand by. We'll post a link here so you can register for the online classes.
Advancing history and politics, education, economic empowerment, entrepreneurship, relationships, love, sex, health issues, and much, much more. Unfortunately, many people confuse what racism is. Racism is a power structure. It was laws and policies that put us in this predicament. It's going to be laws and policies that take us out. So when you control the radius of a man or woman's thoughts, you can control the compass of his or her actions because the mind can't do a piece of what it doesn't know. We have it all on 910 AM Superstation. 910, the Superstation, Detroit's only African-American talk radio.
Welcome back to the African History Network show right here on 910 AM, the Superstation, the Future Radio. I'm your host, Brother Michael Imhotep. Be sure to visit our website, AfricanHistoryNetwork.com, AfricanHistoryNetwork.com. You can register for the online courses I teach on Saturdays and Sundays. On Sundays, 12 noon to 2 p.m. Eastern Standard Time, I teach ancient Kemet, the Moors, and the Maafa. Understanding the transatlantic slave trade, what they didn't teach you in school. We deal with thousands of years of history and what led up to the transatlantic slave trade taking place. We do the sessions live. All the sessions are recorded and archived. You can go back and watch them anytime. Even after the 10-week class is over with, you still have access to all of the sessions. So visit our website, AfricanHistoryNetwork.com, AfricanHistoryNetwork.com. And then we also, because Kwanzaa is coming up, we also have Kwanzaa supplies, your Kwanzaa sets, kanaras, mats, flags, and more right on the homepage of our website, AfricanHistoryNetwork.com. All right, let's continue. So right before the break, we were talking about the jury selection in the trial of the 3 white men accused of killing Ahmaud Arbery. And the jury selection, we ended up with, on yesterday's show, we talked about 65 potential jurors. That 65 has been reduced down to 16 jurors plus 16 jurors, including 4 alternate jurors. Only one of the jurors is African-American. Now, Judge Walmsley said today in court after the court heard arguments for more than 2 hours about why the defense struck the potential jurors, before Judge Walmsley ultimately denied the state's motion and ruled there were valid reasons beyond race why the jurors were dismissed. Ruled there were valid reasons beyond race why the jurors were dismissed. Judge Walmsley said, quote, "One of the challenges that I think counsel recognized in this case is the racial overtones in the case. This is sort of the continuation of a conversation that I think will continue for a long time with respect to this case. the judge went on and said that in Georgia, quote, all the defense needs to do, based upon Georgia state law, all the defense needs to do is provide that legitimate, non-discriminatory, clear, reasonably specific, and related reason. Okay, all the defense needs to do is provide that legitimate, non-discriminatory, clear, reasonably specific, and related reason, end quote, for why they struck a juror. And he said the defense met that burden. The defense met that burden. Now, in Glenn County, where the trial is taking place, more than 26% of the 85,000 residents are African American and 69% are white, according to 2019 data from the U.S. Census Bureau. Now, I want to go over, and we'll go to the phone lines in just a second. This is very important here. I want to go over to this post that attorney Yodit Tawold did today on Instagram, and she's also the host of Making the Case on the Black News Channel. She's a brilliant attorney. She gives brilliant legal analysis. She posted on Instagram today because her show last night was fantastic. They went through and really broke down this case. I watched the whole thing, and she talked to two attorneys dealing with the jury selection. She said, yes, there's one Black juror serving on a 12-person jury in a trial taking place in a county made up of almost 70% whites. And let's see if we can blow this up. In a county of almost 70% whites. Yes, the judge admitted something didn't smell right, but still signed off on the final slate of jurors. And yes, it's frustrating, discouraging, and talking legalese won't make those feelings go away. But it's equally important that there's an understanding of why this happened and why we shouldn't discredit this jury before they've even heard a shred of evidence. Now, see, with me, nothing really surprises me, and I've studied numerous cases. And even in college, we had to take business law in business school. I took basic law in high school. I've covered a number of different cases, being in radio 11 years. So a lot of these things, these people just go crazy about things. A lot of this stuff, yeah. One thing that I focus on is the evidence and seeing the trial all the way out. These different things that people, it's just like when in the killing of Botham Jean, okay, and you had the police officer to kill Botham Jean, and then she appealed the conviction. And then you had people on social media going crazy saying she's trying to overturn the conviction, file appeal. A lot of people get convicted of murder, file appeals. That's routine. Just because you file an appeal, Amber Geiger. Just because you file an appeal, that don't mean that you're going to get a new trial. That doesn't mean the verdict is going to be overturned. I mean, that's just routine. I told people when it happened, I said that verdict is not going to be overturned. We dealt with the entire case here on this show. I said when I read the affidavit, I read the actual affidavit that she gave to the Dallas Police Department, and then I read the one that she gave to the Texas Rangers. When I saw the discrepancies in those two affidavits and that sworn testimony, I said, "Oh, she's going to prison," and she's in prison right now. So this stuff is, I don't get bent out of shape by a lot of this stuff. I just go ahead and see the case all the way through to the conviction and sentencing. So Yodit said, and yes, it's frustrating, discouraging, and talking legalese won't make those feelings go away, but it's equally important that there's an understanding of why this happened and why we shouldn't discredit this jury before they've even heard a shred of evidence. The prosecution challenged the state. The prosecution challenged the defense's move to strike 8 Black potential jurors by raising a reverse Batson challenge, okay, which is a key legal term that you're going to hear a lot. A reverse, by challenging a raising a reverse Batson challenge when one side challenges the other side's use of strikes of jurors on the basis of sex, race, and ethnicity. Okay, when one side challenges the other side's use of strikes of jurors on the basis of sex, race, ethnicity, or religion. It's a challenge often raised by the defense against the prosecution, hence the term reverse, because here the prosecution is doing the challenging of the defense on the basis of race. Okay, here the prosecution is doing the challenging on the basis of race. Here's the three-part test used to evaluate the merits of this challenge. Yodita is brilliant. Okay, she's a former prosecutor. Yodita is brilliant. Here she posted, here's the three-part test used to evaluate the merits of this challenge. 1, the prosecution has to show the defense used a strike for discriminatory reasons. 2, then the defense has to give a race-neutral reason for the strike. You have to explain why you struck this juror. It can't be based upon race. That's 2. 3, the ball is then back on the prosecution side. The burden is then back on the prosecution, where they now have to prove the intentional discrimination, and herein lies the issue. Okay, so if you make a Batson challenge or reverse Batson challenge here, because usually a Batson challenge is the defense making a challenge. Here, the prosecution is making a challenge. So if the prosecution says, if they object to an African-American juror being struck, and they say, okay, the defense is doing it based upon racial reasons, then the defense has to then explain, they have to give race-neutral reasons for the strike. Once they give a race-neutral reason for the strike, now the burden is back on the prosecution to then prove the discrimination. It ain't based upon what you think or feel or believe, is what you can prove. It's not based upon feelings, emotions. It ain't based upon what you think, feel, or believe. Is what you can prove. Herein lies the issue. The judge admitted there was intentional discrimination used during the strike process, but could not do anything about it because no one could prove it. It ain't about what you think, feel, or believe. It's about what you can prove. This is court. This is what I'm trying to explain to people. Okay, this is something on another level. The judge admitted there was intentional discrimination used during the strike process, but could not do anything about it because no one could prove it. So the burden is back on the prosecution. Okay, prove the discrimination. Prosecution couldn't prove it. Besides race, the defense was able to explain why those individuals were struck from the panel. Proving the defense was lying and gave a reason that wasn't, quote unquote, the reason, when in fact the reason was race. Did you get that? Is why Batson challenges are so problematic. How do you prove discriminatory motive? So it's there, but you got to be able to prove it. If you can't prove it, okay, well, you got to argue your case and present the evidence. You have to be able to prove it. You have to be able to prove they're discriminating against the juror. Now, there are so many reasons why lawyers strike jurors. So it's easy to come up with a plausible sounding reason. So trial judges are reluctant to call someone out as being racist and a liar. So there's the how, why, but despite the racial makeup, the jury impaneled should not be discredited for the alleged actions of a few lawyers. That's the headline. Okay. All right. So we're coming up on a break. We'll continue this on the other side of the break. We'll go to the phone lines. The African History Network show. Michael Imhotep. We'll be back in a few minutes. All right. Stand by. Follow your Deep to Wold on Instagram and on Twitter and on Facebook. Okay, stand by. Back from break in 3 minutes. Stand by. Back from break in 3 minutes. How's everybody doing? All right, if you like this type of information, you can support the African History Network. $ the AHN show through Cash App. $ the AHN show through Cash App. Also, give us a thumbs up or a heart on this broadcast if you like this video. Give us a thumbs up on Facebook, YouTube, if you like this video as well. Stand by. Back from break in 3 minutes. Back from break in 2 minutes. Stand by, everybody. Back from break in 1 minute. Stand by, everybody. Back from break in 1 minute. How's everybody doing on YouTube? We got Ruby. Okay, stand by. Welcome back to the African History Network show right here on 910 a.m. the Superstation Future Radio. I'm your host, Brother Michael Imhotep. It is Thursday, November 4th, 2021. We are live, still trying to get used to these breaks every 15 minutes. All right. Let's go to the phone lines. Let's go to Grace, line 18. Grace, thanks for calling the African History Network show. Thanks for holding. Tell us where you're calling from, Grace.
Detroit metropolitan area, and I kind of want to pick your brilliant brain.
Okay.
I've been growing up. I've grown up, and I've always heard you're presumed innocent until proven guilty. Justice supposed to be blind. Jurors can be sequestered during the case. And I would like your opinion on this. Why can't we blacken out a jury when they're being selected to prevent kind of some of this, what's going on? At least let it be an option in the court system.
Some of what was going on. Some, you said the jury was just finished electing the jury today. So you said to keep what from what's going on?
Well, for instance, the buzz about racism is a case about racism. So it's there. It's there.
Yeah, but
the language is there. Their actions are there. Go ahead.
But sequestering the jury is not going to influence that. This is what the defense.
No. I said that is something that's done in the court. Okay. Right. I'm saying blacking out the jury when they're being selected, and you only hear them and go on what they say.
So when you say blacking out the jury, explain what do you mean by blacking out the jury?
Like for instance, we'll say they bring in a big, I guess a shield in the courtroom, and we can't see the individuals that are stepping onto the jury box. So, and the lawyers will be able to go ahead.
So what happens is body language and mannerisms will play also a lot into it, and both the prosecution and defense take cues from body language as well. Okay, so
understood.
Yeah, I don't know of any cases that have operated where you can't see the jury, where the prosecution and defense that's actually choosing the jury can't see the jury. Now they want revealed to the media the race of potential jurors until the actual jury is selected. But I don't know of any cases like that. But let's do this. We see this is only a 1 hour show, so we're about to run out of time. But you can call back tomorrow night, okay? We're on 11 p.m. to midnight, okay? Monday through Friday. Yeah. Okay.
Yes, I thank you. I just wanted your opinion on that.
Okay. Yeah. All right, no problem. All right, thanks. Okay. So very quickly here, I want to go to okay, so we went there for Yodit Tawal Day. Yodit Tawal. If we go back quickly here to this piece from New York Times, nearly all white jury in Arbery killing draws scrutiny. And okay, the guidelines established by the ruling were central to the intense legal fight that erupted in court late Wednesday over the racial composition of the jury in the trial of 3 defendants, which is set to begin on Friday. The argument raised fundamental questions about what it means to be a fair and impartial juror, particularly in a high-profile trial unfolding in a small interconnected community where nearly everyone has opinions about the case. Defense lawyers told Judge Walmsley there were important race-neutral reasons to unseat several Black candidates for the jury. One man, they said, had played high school football with Ahmaud Arbery. Another told lawyers that, quote, this whole case is about racism, end quote. We dealt with some of the comments of some of the jurors and some of the jurors that were struck, as well as some of the jurors that made comments that were allowed to go into the potential jury pool of 65. I don't know how many from the comments that we read here on the show. I don't know how many of that potential jury pool of 65 of those comments that we read actually made it to the to become actual jurors of 16, 12 plus 4 alternates. But the fact that the jury will be composed of 11 white people and 1 Black person in a deep South trial over the killing of an African-American man has profoundly dismayed some local residents who already had concerns about whether the trial will be fair. Now, yes, white supremacy and racism exists. That is true. Okay. And racism is a system of advantage and privilege distributed based upon race, which comes out of the ideology of European white supremacy. That is true. But also what's true is when you get that jury duty notification notice, it'd be a good idea to show up. 1,000 jury duty notifications went out. 1,000 jury duty notices went out. 500 people showed up. 1,000 went out. 500 people showed up. Quote, the jury is a black eye to those of us who have been here for generations, whose ancestors labored and toiled and set a foundation for this community, end quote, said Dolores Polite, a community activist and distant relative of Ahmaud Arbery. Okay. More broadly, the racially lopsided jury in a county that is about 27% Black and 64% white underscores the enduring challenges that American courts face in applying what seems to be a simple constitutional principle that equal justice, quote, requires a criminal trial free of racial discrimination in the jury selection process, as Justice Brett Kavanaugh put it in a ruling in 2019. Those watching on Facebook and YouTube, keep watching. We're going to talk about the Eufaula massacre of 1874 here for a couple of minutes. Visit our website, AfricanHistoryNetwork.com. Register for the online courses I teach on the weekend. Right now, it's correct wrong behavior. It's not over till we win. Wakanda forever. We'll talk to you tomorrow. Peace. All right, stand by, everybody. Stand by. Okay, let's go. Okay. So read this one. Let's see here. Let's continue just for a couple more minutes here on this case. I've got some more information. We'll deal with this on tomorrow's show. I'll be on Roland Martin Unfiltered tomorrow as well. So we'll talk about we'll discuss some of the topics from Roland's show when I'm on the panel Friday. We'll discuss some of that on Friday's show. At the heart of the matter in the Georgia case and many others like it, where white people dominate the jury box, is the ability of lawyers to issue a limited number of preemptory challenges, which usually require no explanation. To strike potential jurors from the process, lawyers typically have wide discretion, but in a landmark 1986 case, Batson versus Kentucky, this is where the Batson challenge comes from. Batson versus Kentucky, the Supreme Court ruled that lawyers could not discriminate on the basis of race in issuing the challenges. The Supreme Court ruled that lawyers could not discriminate on the basis of race in issuing the challenges. Batson versus Kentucky, 1986. Okay, landmark U.S. Supreme Court case. Now, since then, lawyers who suspect the other side of unseating a juror on racial grounds can contest it, a move often called a Batson challenge. That is what unfolded for almost 2 hours on Wednesday, November 4th, at the Glenn County Courthouse as defense lawyers walked Judge Walmsley through the detailed reasons they believe that each of the 8 Black residents should not be seated, such as the pro Ahmaud Arbery hashtags that some potential jurors have posted online, or the negative opinions they had formed about the 3 defendants, Greg McMichael, 65, his son Travis McMichael, 35, and their neighbor, William Roddy Bryan, 52 years old. Now, Laura D. Hogue, Hogue, one of the lawyers for the father, Greg McMichael, described preemptory strikes as an important tool that allowed lawyers to, quote, weed out the worst of the worst. Okay, described preemptory strikes as an important tool that allows lawyers to weed out the worst of the worst, by which she meant who seemed to be irredeemably biased. Now, the lead prosecutor, Linda Dunakowski, pushed back in every case. She argued that a number of potential jurors were honest with lawyers about their knowledge and opinions about the case, but were then unseated by the defense on the basis of those opinions. Even when they stated that they could be impartial if seated. Now, lead prosecutor Linda Dunakowski also noted that the 12-person jury had been selected from a panel that included 12 African Americans and 36 white people. The 12-person jury had been selected for 12 people and 4 alternates, had been selected from a panel that included 12 African Americans and 36 white people. And yet she said, quote, the actual jury that was selected has only one African-American male on it. The prosecution used all 12 of its preemptory strikes on white potential jurors. The defense had 24 preemptory strikes, 8 strikes per defendant, 24. Prosecution had 12. This is Linda Dunikowski here, lead prosecutor. Judge Walmsley spoke like a man whose hands were tied by the law. Quote, I'll tell you, end quote. He said at one point, in this case, Batson's limitations, I think, are clearly out there, end quote. All right. Okay, Barbara Unwine was out there. I've talked to Barbara before. I've interviewed her before. Attorney Barbara Unwine, Transformative Justice Coalition. Attorney Barbara Unwine, who's African-American female, said this is not race neutral. This was racial targeting of Black jurors. It was disingenuous to lie and pretend this was about anything other than getting rid of Black jurors, end quote. All right, now, read the rest of there. Nearly all white jury in Arbery killing draws scrutiny. This is from the New York Times, November 4th, 2021. All right, now, I want to go to this clip here very quickly. It's only a few minutes. This is from Roland Martin Unfiltered today. They talked about the jury selection, only one African-American juror. Roland also spoke with Ahmaud Arbery's mother, Wanda Cooper, as well as family attorney Lee Merritt. All right. In this segment, you hear Dr. Greg Carr, who's on the panel. Dr. Greg Carr, chair of the Afro-American Studies Department at Howard University. But Dr. Greg Carr also has a law degree, and he teaches a class in Howard's law school dealing with race and law. Okay. So, and I've interviewed Dr. Greg Carr a few times as well. That's a brilliant, brilliant brother. I want to go to this clip here where he goes to Dr. Greg Carr here. Let's go to this clip.
Merritt, as well as Wanda Cooper Jones, the mother of Ahmaud Arbery. Thank you so very much, and we'll be following this every single day. Look at my panel right now, Reese Colbert, Black Women Views. Glad to have her on the show. Michael Imhotep, and also Georgia Fort. Glad to have all three of you here. I'm sorry, my bad, Greg Carr. I had the wrong information there. Greg Carr, thanks a lot. Glad to see you here. Georgia Fort, Reese, Greg, and Georgia. Greg, I want to start with you because of your law background. It's very interesting when we cover these cases, how people who don't understand the law begin to realize what happens when you learn, when you're seeing these trials, when you're watching the live streams, when you have lots of attention, to have the judge, to have this white judge go, yeah, this was probably intentional discrimination of these jurors, but then saying hands were tied, it shows you how unequal this criminal justice system is.
Yeah, when people start talking about criminal justice reform, I just start laughing. The system is set up to do what it's doing. The Batson versus Kentucky case, which is the case that tried the issue of whether or not race can be dealt with when you're making a jury selection in the section of a jury, has always been weak. And in many ways, Judge Walmsley's hands were tied. However, a great deal of this is up to the discretion of the judge. Now, no judge likes to be overturned and overruled. And had he allowed for the reseating of some of the jurors who were exempted after rigorous questioning on a Batson challenge, then no doubt the defense would have appealed. And it's called a reverse Batson in this case, as you said, because the prosecution entered the Batson challenge. Normally it's the defense, as you said. But that having been said, his fairly honest description of the white racist criminal justice system was quickly followed by the recognition that the Batson challenge, when you make a Batson challenge, the burden shifts to the defense to put up a reasonable explanation as to why you shouldn't allow for the reseating on race. And when you look at how some of these black jurors were questioned, I mean, you exclude somebody from the jury pool because they knew Ahmaud Arbery? Come on, bruh. Let's be serious. But see, the question then becomes the reasonableness standard. And so you get into the vagaries of judicial decision making based on how you construct what a reasonable person is. And of course, the reasonableness standard then just gets you in a world of trouble because there's no such thing as a reasonable person. This is another way where race operates. And finally, I'll say this. This judge has been on the bench for about a decade. He was appointed by Governor Nathan Deal. This isn't really about his motives, but it is about how the system is stacked against black people. As he said, there are two ways to select jurors. One is the peremptory strike, where you just get rid of people and you don't have to give a reason. That's one way you get rid of a lot of black people in the pool. The other way is the challenge for cause. And that's where you try to get your questions put in a way so that you can create some kind of veneer of reasonableness that will give you the excuse to get rid of black people in the jury. And notice, and I think somebody will probably mention this in a minute, the defense complained because they didn't have enough 40 and over non-college educated white men. They call it the bubble pool. And you might not need a bubble pool. You may not need a bubble pool because you only got one black person in the whole jury pool, including the alternates. They've set up a jury that's probably well disposed to, if there's any way possible to let these guys off, do so. But as Lee Merritt said, it may be difficult even under those circumstances.
Right. Okay. Because the evidence is so overwhelming. Luckily, in this case here, the evidence is so overwhelming. All right. So I want to go to, well, I'm going to post a link here to the full show of Roland Martin Unfiltered from today. And you can watch it on YouTube, watch it on Facebook, Roland Martin on Facebook, YouTube. Watch it on his download the Black Star Media app. Okay, download the Black Star Media app to your smartphone. It's on Roku, Amazon Prime, and I'll be on the show tomorrow. All right, so we have that. Now, I want to go to let's go to this next story here, dealing with some history, this date in history. No, they're not out on bail. November 3rd, 1874, White League attacks black voters. White League attacks black voters. This is the Eufaula race riot of 1874, Eufaula, Alabama. All right. And also, if you like this type of information, you can support the African History Network, $ the AHN show through Cash App, $ the AHN show through Cash App, also through PayPal, paypal.me/the AHN show. Official Cash App tag is $ the AHN show, SHOW. So if you type it in, make sure you type in the full tag because there's some fake African History Network Cash App accounts out there that I'm trying to get shut down. When you go to ours, it shows it says Michael, and it shows my picture there, and our actual Cash App tag is $ the AHN show, SHOW. All right, so if we look at this here, in the various massacres, and I teach about this in my online classes, especially from the Civil War to the Civil Rights Movement and Black Power, 1865 to 1968. This one is not talked about a lot, Eufaula. We know in the, this is during Reconstruction era. A lot of these take place during Reconstruction or right after Reconstruction. The documentary from MSNBC, the Civil War, The Roots of Our Division, in that one, they talked about the Clinton, Mississippi massacre, Clinton, Mississippi riot of 1875. And we've dealt with that here on this show as well, also during Reconstruction. But if we look at this here from the Zen Education Project, on November 3rd, 1874, deadly election riots took place in Barber County, Alabama. Deadly election riots took place in Barber County, Alabama. You're going to see a lot of these massacres, a lot of these race riots take place around elections and political power. Elections and political power, and they're trying to suppress the African American vote and keep us from voting and lock us out of political power, lock us out of political office. And we see this continue today with the voter suppression laws in states dominated by Republicans. We see this continue today. The White League, which was a paramilitary group affiliated with the Democratic Party back at the time during Reconstruction. This is before the Compromise of 1877, which ends Reconstruction. This is before the party realignment that is completed in the late 1960s, but begins in 1928 with the Lily White movement in 1928. The White League, a paramilitary group affiliated with the Democratic Party, attacked African-American voters at the polls, at the voting polls in Eufaula and Spring Hill, Alabama. Eufaula and Spring Hill, Alabama. 7 African Americans were killed, and 70 others were wounded. 70 African Americans were killed, and 70 others were wounded. More than 1,000 African Americans were driven away from the polls, from the voting polls, due to violence, due to the violence of the white supremacist group. They were trying to intimidate African Americans, suppress our vote. This is during a period of time during Reconstruction. You're going to have about 2,000 African Americans that get elected into political office. We're in the state legislature. We're in the U.S. Congress. You're going to have two African American U.S. senators. Okay, and you have former slaves who are voting and writing laws that are impacting their former slave masters. And there's going to be a huge backlash from this. In 1871 in South Carolina, President Ulysses S. Grant is going to have to declare martial law in 9 counties in South Carolina to crack down on the Ku Klux Klan because they were attacking African-American elected officials, white Republican elected officials, things like this. He used the Ku Klux Klan Act of 1871. More than 1,000, 1874, Eufaula, Alabama, more than 1,000 African Americans were driven away from the voter polls due to the violence of the white supremacist group, the White League, as explained on the Encyclopedia of Alabama website. On election day eve, there may have been as many as 1,000 or more African American men from Barber County camping out on the outskirts of Eufaula. Accounts citing figures vary. In addition, persistent but false rumors of an invasion, persistent but false rumors of an invasion of the city circulated within the white community. So you're going to hear terms like invasions, different things like this, just like some of the white racist dog whistling that Republicans will use, Donald Trump will use today. You're going to see this back then. You're going to see how rumors, conspiracy theories led to massacres and African Americans being killed, just like rumors and conspiracy theories led to the January 6th insurrection. And they're continuing to spread rumors and conspiracy theories and the big lie and things like this. And when white people spread lies, black people die. When white people spread lies, black people die. In addition, persistent but false rumors of an invasion of the city circulated within the white community. Republican politicians and officials were thrown out of office. The White League did not count the votes cast for Republican candidates, and the Democrats were declared as winners of the 1874 elections. Okay. Similar events took place in Georgia, Mississippi, North Carolina, and South Carolina. You're going to have white supremacists taking back control of the political structures in these southern former Confederate states. All right, this is during Reconstruction. We're going to see this at the toward the end of Reconstruction and then after Reconstruction. Then they're going to start rewriting their state constitutions. Mississippi, Alabama, Mississippi 1890, Alabama 1901, Louisiana 1898, South Carolina 1895. We're going to see them rewrite their state constitutions and impose poll taxes and literacy tests to suppress the African American vote. Now, these riots, state-sanctioned violence, voter suppression, and Democratic Party-controlled government signaled an end to the Reconstruction era, but it was also Republicans conspiring with Democrats with the Compromise of 1877, where Republicans told the Democrats, if you allow Rutherford B. Hayes to become president, because neither Rutherford B. Hayes nor Samuel J. Tilden had enough electoral college votes to become president. There were disputed election results in Louisiana and Florida and South Carolina. They said, if you allow Rutherford B. Hayes to become president, when he becomes president, he'll remove the remaining Union troops out of the South. And this is what the Democrats wanted. So Republicans conspired with the Democrats with the Compromise of 1877. Read this piece here from the Zen Education Project, ZINN. November 3rd, 1874, White League attacks Black voters. Now, they have a historical marker here. And if we look at this here, let's try to zoom in on this historical marker. Election riot of 1874. Let's see, try to zoom in on this. Near here is Old Spring Hill, the site of one of the polling places for the November 3rd, 1874 local, state, and national elections. Elias M. Keels, scallywag and judge of the city court of Eufaula, was United States supervisor at the Spring Hill ballot box. William, his 16-year-old son, was with him. After the polls closed, a mob broke into the building, extinguished the lights, destroyed the poll box, and began shooting. During the riot, Willie Keels was mortally wounded. The resulting congressional investigation received national attention. This bloody episode marked the end of Republican domination in Barber County. This is a historic marker erected in 1979 in Eufaula, Alabama. This is the election riot of 1874 in Eufaula, Alabama. The White League attacks Black voters. All right. So you can check this out here. And this is some of the type of information we deal with in my online classes, especially from the Civil War to the Civil Rights Movement and Black Power, 1865 to 1968. Okay, so visit our website, AfricanHistoryNetwork.com, and you can register for the courses there. As soon as you register, you can start watching the content. And then we also have the Kwanzaa shop here, Kwanzaa sets, kanaras, candle holders, mats, flags, and more. This is courtesy of Sister Nubia Wartford, the archaeologist who you've heard me interview a number of times. Add the early bird discount code for $10 off before November 28th, 2021. Okay, and click right here to visit thekwanzaashop.com. Here's information for my online course, 10-week online course from the Civil War to the Civil Rights Movement and Black Power, 1865 to 1968. So the class is on sale, $70. As soon as you click right here to register here, then click on enroll. As soon as you register, you can start watching the content. You can watch the class we did last week. All right. Okay. Look, we have to get out of here. Remember, at the African History Network, we focus on And we'll post this link here also so you can register for the class. Remember, at the African History Network, we focus on educating, empowering, and inspiring people of African descent throughout the diaspora and around the world, because right now it's correct wrong behavior. It's not over till we win. Wakanda forever. African American business owners, email us at AHNshow@AfricanHistoryNetwork.com. AHNshow@AfricanHistoryNetwork.com. We'll let you know how you can advertise with the African History Network. We take your 30-second and 60-second commercial and put it into the rebroadcast of our shows that we broadcast on our social media platforms, but also into the audio podcast of our shows. We're on 10 different audio podcast platforms, including on Facebook podcasts as well. All right. So we're on Castbox, FM Player, TuneIn. And if you don't have a commercial, we can create one for you, no additional charge. So you can reach thousands of potential customers on a weekly basis. Email us at AHNshow@AfricanHistoryNetwork.com. A current promotion: buy 1 month, get 2 months free. We have to get out of here right now. Let's correct wrong behaviors. Not over till we win. Wakanda forever. And we'll talk to you tomorrow. And I'll be on Roland Martin Unfiltered on Friday as well.
On Purpose Television Network. Yes, Black on Purpose Television Network. All black, all positive, all the time. The largest black-owned streaming television network in the world, bringing our people together worldwide, controlling our messages, our story, our way. Black TV the way it should be. Black music, Black history, and more. 30+ channels, thousands of shows. Black on Purpose Television Network. Subscribe now.
Gain knowledge in minutes from insightful summaries of progressive and socially conscious books. Blacklisted gives you access to curated content that'll satisfy your curiosity to learn and understand different perspectives. Empower yourself through inspirational and actionable ideas. It's easy to read or listen to on the go. Blacklisted. Empower yourself. Start your free trial today.